All right. So I have to talk to you about a ruling that came out at the end of last week. And it is a ruling many people have asked me to comment on the case in general. And now we actually have a ruling in the case, which is probably the best time to go ahead and comment on it. And I am talking about the United Methodist Hospital case down in Houston, where about 117 workers did not want to receive the COVID-19 vaccination as a requirement for their continued employment. Those workers were suspended. Actually, I think it's a bigger number were ultimately suspended, but 117 of them sued the hospital system, saying that the hospital should not be able to force them to have the vaccine. Now, the judge has ruled in favor of the hospital. It has said that the hospital has a right to request that its workers have the vaccine or suspend or even terminate their employment in the state of Texas. Now, this is what I have said would probably be the outcome when people ask me about it. I've talked about it on a couple live streams, and people don't like that answer. But stick with me for just a second. This is not a question of what I think the law should be or what I think the right result should be. It's what I was pretty sure the law actually is and how it actually works. I know people really wanted to go ahead and have this ruling go in favor of the hospital workers. Heck, so do I. I am not a fan of forced or coerced vaccinations of any stretch. I think people should make those decisions individually based on their own research, knowledge, and consultation with their licensed healthcare professionals. That's what I think should happen. So I'm not a fan of coercion or forced vaccinations in any way. So people are mistaking my legal opinion on what was going to happen with what I think should happen. So let me say this very clearly up front, and then I'll tell you why it happened. We'll actually take a look at some of the factors that the judge weighed in, and I'll address some of the questions that I know are coming. Make sure you watch through the whole video so we get through that. But before you understand what happened, you have to understand that I don't think this is the proper moral outcome. It's just the legal outcome that I predicted based on the existing law. Frankly, Texas is an at-will state, and because of its at-will status, employers are at the liberty to request employees to do almost anything, so long as that thing is not illegal, as a prerequisite for employment. And yes, that includes a changing condition. If you are working there, they can suddenly inject, if you will, a new requirement to go ahead and maintain your job. At-will employment is not contract-based, and the employment agreement can be severed at any time, absent a separate contractual agreement clarifying the worker and employer relationship. So, let's get into this. It's a contentious subject, and I wanted to leave that long preface. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey, wherever you're watching. Hit the like button, hit subscribe, turn on your notifications. I don't want you to miss any of these videos. Okay, so what are we talking about here? We have judge rules in favor of Houston Methodist hospital system, in brackets there, in lawsuit over COVID-19 vaccines. This is from clicktohouston.com. You can go ahead and follow the link in the description if you want access to this article. I will link it down there. Not a ton that we need to take from it, but if you want to follow up, you can. All right. Let's start addressing some things here. There are a couple theories of this employment law case. One is that of wrongful termination, and the other is a public policy argument that requiring these vaccines violates an existing federal statute, and that is 21 U.S.C. 360 BBB-3, I believe, is the statute that people are talking about. This is what people bring up to me when I suggested that while I sympathize with the workers, and I think they have the morally correct position, that I think the law was going to come down in favor of the hospital in this case. People said, no, 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 this 21 USC 360 BBB, that says that they can't actually require this vaccine. Well, unfortunately, I hate to break it to you, that's not quite what the statute says, and the judge actually does address this argument. Now, this is something people don't understand. You are free to disagree with the judge on a moral level, and you are free to disagree with the judge's legal interpretation. But as of right now, this is the legal ruling that will be in effect. They have already said, the workers have already said that they will be filing an appeal. They do not believe this is a correct decision. And it is possible that a Texas appeals court will come down in favor of the workers, although I still think that's an unlikely thing in an at-will state, because at-will private employers that are not government employers have a lot of leeway in what they ask their workers to do. So let's take a look at the article, and then we'll address those two main bases, and maybe we'll take a look at what the judge said specifically on it. So here we go. Federal judge dismissed a lawsuit Saturday from a group of Houston Methodist employees opposing the hospital's COVID-19 vaccine mandate. 117 employees sued the hospital over its policy requiring staff to get the vaccine or to be fired. Quote, "This is not coercion. Methodist is trying to do their business of saving lives without giving them the COVID-19 virus. It is a choice made to keep staff, patients, and their families safer," said U.S. District Judge Lynn Hughes. Now, at first glance, this statement from the judge seems to be overly prejudicial, but it comes later in the opinion, and the judge's legal reasoning is up front. Again, I'm not endorsing the legal reasoning or the moral opinions of the judge here. I'm just trying to tell you what the judge's reasoning was in this and why the law tends to favor the hospital in this situation. The judge also denied a request for a restraining order to block Houston Methodist from suspending the unvaccinated employees. Hospital's vaccine deadline was last week, and more than 170 employees were suspended without pay for the next 14 days after not complying with the vaccine requirement. In the lawsuit, this is a quote from Houston Methodist. It says, "In the lawsuit, the plaintiffs falsely claim that the COVID-19 vaccines are not safe. With more than 300 million doses administered in the United States alone, the vaccines have proven to be extremely safe. The number of both positive cases and hospitalizations continues to drop around the country, proving that the vaccines are working in keeping our community protected," Houston Methodist wrote in a statement. Now, there's a lot of logical issues with that, ignoring some of the very real concerns people have about the vaccine and stuff like that. But remember, this is coming from the Houston Methodist hospital system, the employers themselves. This is obviously going to be a biased statement, biased in favor of themselves. Now, Jared Woodfill, who is the lawyer representing the employees, said they will appeal. Says, "All of my clients continue to be committed to fight this unjust policy. What is shocking is that many of my clients were on the front line treating COVID-positive patients at Texas Methodist Hospital during the height of the pandemic. As a result, many of them contracted COVID-19, and as a thank you for their service and sacrifice, Methodist Hospital awards them a pink slip and sentences them to bankruptcy." So, pretty fiery rhetoric coming from the lawyer there, suggesting that the hospital has nefarious purpose here, and I agree with him in that there's no consideration going into these employees who may have different decision-making things. Maybe they got COVID and they believe that their own immune system is sufficient, whatever it is. Again, I'm not them and I'm not their doctor. It's not my decision to make. And I also don't think it should be their employer's decisions to make. But that being said, employers get to make a lot of decisions because people are simply free to not contract with the employer. And that is going to be the ultimate basis for this. So we're going to skip the background and go straight into the wrongful termination section of the actual decision here and take a look at the judge's reasoning. So Bridges dedicates the bulk of her pleadings to arguing that the currently available vaccines are experimental and dangerous. This claim is false, and it is also irrelevant. So again, the judge seems to have a bias here in favor of the vaccines, which is one thing to consider, but the judge is saying that even in light of the falsity there, the alleged falsity, I should say, that it's irrelevant. And this is the part that's important. And this was what was informing me when people asked the questions, do you think this lawsuit has any legs? And I said, I don't think so, because of at-will employment and how strong that protection is. So here we go. Bridges argues that if she is fired for refusing to be injected with a vaccine, she will be wrongfully terminated. Vaccine safety and efficacy are not considered in adjudicating this issue. Texas law only protects employees from being terminated for refusing to commit an act carrying criminal penalties to the worker. To succeed on a wrongful termination claim, Bridges must show that she was required to commit an illegal act, one carrying criminal penalties. She refused to engage in the illegality. She was discharged, and the only reason for the discharge was the refusal to commit an unlawful act. So this is the judge's interpretation of wrongful termination in the state of Texas under the existing case law that's out there. And this will probably be one of the points that they are appealing. The lawyer for the employees is going to try and find some competing language in existing case law to suggest that there are non-criminal acts that employees can be required to do, and that would be a wrongful termination. For example, can an employer coerce an employee into sexual activity and then terminate them when they refuse? I mean, no. But that wouldn't sexual activity is not an inherently illegal act carrying criminal penalties. So there's not quite a fully accurate statement on the law, because we would not allow an employer to coerce an employee in such a way. But under general provisions of wrongful termination, the judge is saying that no, you do not have the right to, or you don't get to just refuse what an employer demands, but then still demand that they pay you and keep you employed. So Bridges does not specify what illegal act she has refused to perform, but in the press release style of the complaint, she says that she refuses to be a human guinea pig, and that's where she talks about testing. So she also argues that the injection requirement violates public policy. Texas does not recognize this exception to at-will employment, and if it did, the injection requirement is consistent with public policy. Supreme Court has held that involuntary quarantine for contagious diseases and state-imposed requirements of mandatory vaccination do not violate due process. This is a problem with the United States Supreme Court because these things do, in my opinion, violate due process. But that's me. And they're going back to some old cases here, 1905 and 1902 for these rulings. So, I mean, they're cases that are still there and still valid, but we're talking about some pretty old handlings of epidemics at the time, or contagious diseases. All right, so here we go. The next part of this is the public policy argument, and this is where we get into the actual statutes, okay? Bridges also asks this court to declare that the injection requirement is invalid because it violates federal law. She says that no one can be mandated to receive unapproved medicines in emergencies, and she insists that no currently available vaccines have been fully approved by the Food and Drug Administration, and this is talking about 21 U.S.C. 360 BBB-3. But that is an authorization to the Secretary of Health and Human Services, the judge says. Federal law authorizes the Secretary of Health and Human Services to introduce into interstate commerce medical products intended for use in an emergency. It also requires the Secretary to ensure product recipients understand the potential benefits and risks of use and the option to accept or refuse administration of the product. That is the government. That is a requirement on the government to allow people to accept or refuse administration of the product in the emergency. The government cannot mandate a vaccine, and we haven't seen cannot mandate the emergency use of the vaccine, or the Secretary of Health and Human Services can't, I should say. And we haven't seen the Secretary of Health and Human Services attempt to do that. So the judge is saying this law restrains the Secretary of HHS, not private employers. So Bridges has misconstrued the provision. It confers certain powers and responsibilities to the Secretary of Health and Human Services in an emergency. It neither expands nor restricts the responsibilities of private employers. In fact, it does not apply at all to private employers like the hospital in this case. It does not confer a private opportunity to sue the government, employer, or worker. Bridges claimed that the injection requirement violates 21 U.S.C. 360 BBB-3 fails. The judge also goes on to address one more aspect that I've seen brought up a couple times, and that is that it violates the Nuremberg requirement against coerced activity. But that is a requirement that is similarly binding on government, not on private employers. The method to sort of the legal thought process, I should say, behind this is that mandating a vaccine or mandating an activity from the government as an act of law or as a matter of state demand is confers with it some sort of implied government penalty. Even if that penalty isn't specifically laid out, if the government mandates vaccine use and you don't get the vaccine, one is constantly left wondering what's going to happen to them when the government decides to act on that failure of them to follow the government mandate. So even if there's an absent specific criminal penalty, we have to ask what the government will do when their mandate isn't followed. Not so for private employers. See, citizens of the government can't escape the government under which they are a citizen. In fact, to even leave the country in some ways requires permission from the government. At whatever border crossing you tend to do, if you intend to do it in a legal way, you tend to have some sort of check that the government does. Now, it may be a very cursory check, or it could be a very in-depth check, and there's all sorts of separate law around that. But there is nowhere to go when your government decides that you are in the wrong. You are subject to the government's jurisdiction, and as long as you are, you don't really have a freedom of choice when the government is compelling an act. It's your freedom to be in violation of the law. With a private employer, you are free to not contract with that employer. And that is the reasoning and rationale and the big difference between government coercion and private entity coercion. Now, again, just so everyone is clear, because I know people are already typing and yelling at me in the comments. This is not what I think is right. It's just how the law has worked. And the pandemic and all of the emergency authorizations that we've gotten, and some of them are being struck down in individual states. We've got Florida and Kentucky striking them down, hopefully some others to follow. But all of these mandates and power that we allowed the government to take have manifested in an acceptance at the private sector level that is much higher than we've even tolerated for government, because the private sector is not a state actor. So since we have given ground for the government to do what they've done, the private entities are allowed to not only follow suit, but exceed the government mandates, because you are free to not contract with the private entity. And I know that does sound very harsh when we're talking about employment, and there's lots of considerations there, but that is the nature of at-will employment versus contract employment. Texas is an at-will state by default. You can override it with a specific contract, but it looks like the United Methodist hospital workers do not have a contract that allows them to overcome this sort of requirement, because if they did, I assume that would be brought up in their wrongful termination plea rather than what they actually put in there. So right now, Texas employers can mandate a vaccine, and I've covered this in other videos. That is the legal reality that we're under, is that most private employers do have the power to demand that you take a vaccine. They have and before you bring up HIPAA and all of that other stuff, employers have a right to ask for your medical information in several instances that have been upheld as legal under HIPAA for a very long time. Again, you don't have to agree that it is the correct thing, but you have to understand that it is the current status of the law. So we need our lawmakers to come in and change it. Judges are not going to save us. I know people don't like this, but you're going to have to vote. And yes, that system is broken too, but it's the best chance that we've got. So That being said, feel free to rip me apart in the comments and tell me how I'm horrifically wrong, but this is the news about this thing. I'll be anxiously awaiting the appeal to federal courts, and I think these questions do need to be asked and do need to be appealed. Just because I think that the judge came down the way I think the law sits doesn't mean that I think it's the right answer, and maybe the appeals court will see it in a different light. Actually, hopefully they will, because I am not in favor of mandatory pokes coming from government or private employers. But again, tell me what you think. Thanks again for watching. Until next time, peace. Peace.